What I have for you today is a transfer pricing case in oil and gas. And it has a bit of personal history as well, in the sense that this case, I was working at AP Moller Maersk before, and though I wasn't very involved with Maersk oil and gas, I was aware of what was going on. And when I changed to the Danish tax authorities, they actually started working on this case. They started before I got there, but this case continued, and it seems like it now finally came to fruition. So let us look at it. And the first thing that I must say is what baffles me, and this is the Danish Regional Court, it's not the Supreme Court, but they published a summary of the case, which you can see uses all the names of the different companies: Total Energies, EP Denmark, the earlier Maersk Oil and Gas AS, was 100% daughters or subsidiary of AP Moller Maersk AS, etc., etc., etc. Right? But when they've published the final case, they made it anonymous like this, and I don't understand why. I mean, if the same institution has published the case with the names of all the parties, why would you then go and anonymize it like this? Anyway, I will use the names of the companies in this case. I think that is easier to read and easier to follow. Here is a summary of the facts, and I will leave you to read the detail for yourself. But basically what it says is Maersk Oil and Gas, MoGas, was 100% subsidiary of AP Moller Maersk AS. In 2018, MoGas business consisted of three main areas. Firstly, it was an operator in the Danish part of the North Sea, the Danish Underground Consortium, or DUC, and this is where they pumped up oil, I believe, together with Shell and Exxon. That is public knowledge. And MoGas was indeed the operator. MoGas also carried out preliminary feasibility studies in various parts of the world with a view of finding new oil fields. That's what you do if you're an oil company. After which subsidiaries and branches were established with a view to further exploration for oil. And this is one of our problem points in this case. We'll have a look at that. And then MoGas provided a number of technical and administrative services, so-called time writing, to other companies in the group. Now, MoGas subsidiary, Maersk Oil Algeria KS, which is a special form of Danish partnership, joined a consortium in 1990 with the oil companies Anadarko Algeria Corporation and Lasmo Oil Algeria Limited. Maersk Oil Algeria AS, so this is a different entity, was the managing partner in Maersk Oil Algeria KS, the partnership, and MoGas was the limited partner. In 1994, it sounds like they rolled up the structure because the limited partnership's assets and liabilities, including oil rights, were transferred to Maersk Oil Algeria AS. And this was 100% subsidiary of MoGas. And then Maersk Oil Algeria AS participated through its local branch in two partnerships with the partners Anadarko Eni and the state-owned company Sonatrach. Anadarko was the operator, so it did all the work like MoGas did all the work in DUC in the North Sea. And Maersk Oil Algeria AS and the company's local branch in Algeria had no employees in Algeria. We'll come back to this point. MoGas subsidiary Maersk Oil Qatar was founded in 1992 and a local branch was established. Maersk Oil Qatar AS entered into an agreement with the state of Qatar on oil extraction. The branch operated the activities alone, and it was self-operator of an oil field called El Shaheen. So these are a 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Just quickly to illustrate them, this is AP Moller Maersk and MoGas, and then you've got the two subsidiaries, and they both have branches in respectively Algeria and Qatar. And Algeria, there were no FTEs, and they worked together with Anadarko, which was the operator, Eni and Sonatrach, and in Qatar, Maersk Oil Qatar AS operated solely in the El Shaheen field. So let's see what happened. Before we look at the court decision, we just need to understand, for those of you who are not in the oil business, the stages of going through an oil field, right? First, you have a regional survey, and I'll leave the detail for you to read yourself, but you have a regional survey in which you do analysis by magnetic shots and seismic data and stuff like that. Then you go to feasibility and commitment moment, and then you start with the real exploration, the appraisal, the development, but by the time it's development, that's when you bring the drilling rigs in and you start drilling for oil. Then if you find it, you go to production, the extended oil recovery. So that's when you just pump up oil, whatever is in there, and then abandonment, which means you've got to close down everything properly. And the way that the Maersk Oil and Gas operated was Maersk Oil and Gas did the first two phases itself, right? And then it transferred these fields to its local subsidiaries or the local PEs, and they then did the rest. And the reason why you did this is obviously when you transfer intercompany, you must pay a transfer price, right, for transferring the oil field, because that's what you would do with a third party. And you don't want to do it too late, because then you don't want to do it too late, because then it's become too valuable. If everything is certain, then there's obviously a high price to the oil field. So you don't want to do that, but you also don't want to do it too early, because then you just end up with foreign subsidiaries or foreign branches with losses that you can't use anywhere. So Maersk Oil and Gas chose to do it after phase 2. There's still a proper amount of risk involved, and the price was relatively low, and then the local subs did the rest of the phases. And if we look at what the National Tribunal said about this, the High Court summarized as follows: says the majority of the National Tribunal assumed that the branches in Algeria and Qatar have used intangible assets which must be considered owned by MOGAS, and characterize these intangible assets as know-hows and the rights to the oil extractions in the form of licenses, right? And they assumed that a fee would have been paid between independent parties for the use of these intangibles. The National Tax Tribunal emphasized that MOGAS has borne the costs of preliminary investigations called phases 1 and 2, and that MOGAS makes the rights to extraction available to the branches. So it grants an opportunity to the branches by giving them or selling them its oil licenses, right? It almost sounds a bit like the opportunity argument from the Canadian Cameco case, a bit along the same lines. And then it continues and says the majority of the National Tax Tribunal has emphasized that MOGAS guarantees the subsidiaries' obligations via performance guarantees, and they ended up upholding the Danish tax authorities' assessment of 175 million euros, because they simply said, it can't be so that MOGAS is making losses while all these subsidiaries are making, or their branches are making, these incredible profits. So let us look and see what the questions in this case are. The first one is, should MOGAS have charged a royalty to Algeria and the Qatar activities, right? That's already what the regional court, the lower court, has said. Should MOGAS have charged a performance guarantee? Or the lower court said that they definitely should have. Was there a 0% consortium services cup? And we'll get to that argument in a moment, but basically MOGAS said that, we're not charging our consortium partners anything for all the administrative work that we do while we're the operator, and therefore we should not have to charge group companies either. And then the court made the point, and I just want to underline it here, that a dividend is not a TP payment. And the question is, could the TP documentation be rejected and a pro forma assessment be made? And then could the burden of proof be reversed? And MOGAS had to prove that the tax authority's assessment is way too high. And this is a go-to argument of the Danish tax authorities that they tried here as well. So if we look at the deemed royalties, the High Court says it finds that the subsidiaries are both formal and real owners of the oil extraction licenses in Algeria and Qatar. So it takes a very formalistic point on this and says, these are the legal owners, so therefore it's theirs. It lays emphasis, the court, on the applicable contract law basis as well as the company's accounts, right? So the court just stays formal. So it must be it must be considered undisputed that MOGAS is not a licensee. it cannot then be argued that there was a transaction between Mogas and the subsidiaries in 2006 to 8, which was the years of assessment, covered by Danish TP rules in that licenses for oil extractions were made available to the Mogas subsidiary. So the Danish tax authorities argued, you know what, actually the real owner of the licenses were, or that's what they seem to have argued, was Mogas, and it just made these licenses available to the local subs, and therefore they should have paid a royalty for using these licenses. The court goes on to say it's undisputed that the feasibility studies carried out in phases 1 and 2 concerning Algeria and Qatar were terminated by Mogas in 90 and 92 respectively, and that Mogas has not incurred expenses for the subsequent phases. The tax authorities assumed, as mentioned, that a compensation would have been paid between independent parties in the form of a profit share, a royalty, or the like. The High Court finds that no such payment would have been made between independent parties. And what we don't know here is whether Mogas did transfer the licenses against a small fee or just gave it for free. I would have argued that you should have given the licenses against a small fee to at least to cover your desktop review of the seismic charts and all those kind of things, because that's what you do with a third party. But it wouldn't have been a lot of money, right? Because there's still a lot of risk involved in doing 3D studies of seismic charts, and hiring drilling rigs at anything between $200,000 and $600,000 a day and sending them out to go and drill and hope that you find oil, right? So from that point of view, it's definitely clear that Algeria and Qatar subsidiaries did take significant risk, right? The court emphasizes the nature and content of the preliminary investigations in phases 1 and 2 compared to the following phases, which was what we just talked about, including the associated costs and the uncertainty which is still associated with the oil deposit and its exploitation after phases 1 and 2, because phases 1 and 2 is no guarantee that you will have oil. And the court then quotes what the expenses were comparatively, right? It says Mogas expenses for the feasibility studies in Algeria and Qatar are not presented in detail. But this is what we know. Mogas' total expenses for exploration in 1986 to 91, which include Algeria and Qatar, is approximately 128 million kroners, which is probably about $20 million, right? The cost for further exploration, production, etc. is borne by the subsidiaries, and the total cost of investigations incurred by the subsidiary in Algeria for 1990 to 2010 was approximately 759 million, so much more than what Mogas spent in the rest of the world in the 5 years, while the total expenses for Qatar for the same period is calculated at approximately 527 million. So again, significantly more than what Mogas paid.